and I'll do a share screen. If you wish to ask any question about tonight's topic, I suggest we defer it a bit so that for now we can just focus on the Happiness for Learning mini workshop. So the reason why I thought about this is that to me, it makes sense for people to want to be happy. Who doesn't want to be happy, right? But we often think that happiness is mainly a consequence, for example, of our situation, so that if your circumstances are good, then you must be happy, or you could be happy. But if your circumstances are bad, then necessarily you must be unhappy. And so I've done a lot of reading on it, a lot of research, and I suppose just like a lot of you, I've been through my own struggles, personal difficulties. I've been through a difficult divorce 2 years ago, had to go through the court system to fight for child custody, and I went through clinical depression. And I figured, if I am going to function and do my job, and more importantly, to flourish as an individual, then I needed to do something about it. And that got me around to looking into happiness, especially because I've come across other people who went through difficult situations, like they had a divorce, and their lives just unraveled. They simply unraveled themselves, and they themselves unraveled in the sense that they continued to be depressed even after 1 year, 2 years, 3 years. And I said, I don't want to be in that spot where you just keep on going down a spiral where it's so difficult to come out of it. And so let's just say that I have a huge interest in happiness. And the idea about happiness, for some of you who are a bit older, you've probably heard of Ogmandino, maybe not. But there was a time when you talk about positive affirmations and how these can make a difference in one's lives. But a lot of these things in the past were actually not based on evidence, but there has been a lot of research going on, mainly as a result of Professor Martin Seligman, who at one time became the president of the American Psychological Association, who suggested that psychology, for example, shouldn't focus only on what ails the mind or what ails the human person, but to talk about ways of human flourishing. And so instead of looking at the negative side of people's feelings, there was what is known as positive psychology, which focused on what is positive for humans and what can make them flourish. And courses on happiness have actually been offered in a lot of major universities all over the world. And my sense is that people who are happy, students who are happy, are likely to flourish, both as students, but as well as in their personal lives. So that's the reason we're having this. Initially, for the first 2 sessions today, and the one we're going to have next week, for the 10 minutes prior to the tutorial, we'll talk about happiness and unhappiness, and then we look at actual workshops on what we can do to actually become happier. So that's what the focus is going to be. But for now, we'll try to delve into the research a bit. So after this session, what I'd like you to do is to be able to critically reflect on what is happiness, whether success leads to happiness, or whether it is happiness that leads to success. And I'd like you to critically reflect on the value of being happy and the costs of being unhappy. Now let's begin by talking about what exactly is happiness. Now, a lot of definitions have been proposed in relation to happiness. And before I get there, perhaps I should ask you, do you mind, we have time, just for a few seconds, do you mind putting in the chat box, what is your definition of happiness? Can you do that for us? This is critical reflection, so you can't just be listening to me. You need to do something. So can I just ask you to type in the chat box, what to you is happiness? So in other words, if somebody were to ask you, are you happy? You'd have an idea about what happiness is. What exactly is happiness to you? Let's just give it a few seconds. Okay. How about the others? Very good. Okay, fantastic. Very good. Okay, now, very good, Rod. Positive reflection, very good. Traditionally, when you think about happiness, we assume that happiness is having very positive feelings. So you know when you're happy because you're feeling good. But have there been times in your life when you were doing something which you can't say would really make you happy in the sense that, it's a positive, pleasurable feeling, and yet when you think about it afterwards, you say, I was happy. For example, taking care of children, taking care of family members, doing a very important task, such as trying to finish an assignment or finish a project. Does it make you jump with excitement? Does it give you pleasurable feelings? Or, notwithstanding, maybe what might be considered to be unpleasant, can it be said that you actually derive pleasure, satisfaction, even happiness for certain activities which can actually be unpleasant or not necessarily pleasurable? So like going to the gym. In my case, about a year ago, I was actually, okay, so I'm overweight, okay? So I'm overweight according to the BMI index. So my weight as of, when was that? December of last year was about 100 kg. Before then, my weight was about 108 kg. My weight has now dropped to 90 kg. And I did that because I've got young kids. I've got a 6-year-old child, and I felt like, I don't want to die earlier because of a heart attack and stroke. And so I do my best to go to the gym. For those who've been to the gym or who go to the gym, it's not really pleasurable to be, running on a treadmill, going on a bike, doing a lot of these physical activities. They're not necessarily pleasurable, but they can give you meaning. And therefore, as a result, they actually make you happy. In the same way that when you think about it, doing projects, taking care of your kids, a family member, they're not always pleasurable in the sense that, you could have a child who's complaining, throwing tantrums. You could have a family member who's unhappy about what you're doing, and yet you derive some satisfaction about what you're doing. So happiness has been proposed to mean it is sustained experiences of pleasure and meaning. So in other words, you could be happy because you're engaging in pleasurable activities. You've got positive emotions of positivity, gratitude, serenity, interest, hope, joy, and so on. Or you could also be happy because you find meaning in what you're doing, even if at the time you're doing it, you're not really filled with some, very positive emotions. Now, for those people who are just all about pleasure, and then there is no meaning, and because you could have pleasure by, drinking, always going, to parties, having fun and so on, and yet you lose the meaning of what life is all about. Some would argue that it's difficult to say that you can have sustained moments or experiences of happiness. So happiness is really having the balance of pleasure and meaning. And Paul Dolan, for example, suggests that when sometimes you're being asked, are you happy? So that's an evaluative self. Like I ask you now, are you actually happy? Which isn't really the same as experiencing happiness. So when surveys are done and people are asked, are you happy? Somebody will say that I'm actually happy in my job. And yet when they think about, the moment by moment experience of being in the job, it's actually not, they can't really say that they're happy. It could be like in your relationship, how are you happy in your relationship? And people can say, oh yeah, I'm happy in my relationship. And yet on a moment by moment basis, on a day-to-day basis, in terms of the experience, it is possible that the experience isn't really happy. So there's a difference between evaluating, thinking about it, and experiencing it. I don't know if it makes sense, but that's what the literature says. So anyway, it's 7 o'clock, so kind of cut it there. I'll give it 2 more minutes because we're just going to give others time to catch up. What I'd like you to do next, so think about these. I'm going to post this in Moodle shortly, and I don't mind extending our session tonight. So don't worry if I kind of extend a bit. when we discuss this. The other thing I'd like to ask you is, what do you suppose comes first? Is it the chicken or the egg? Would success be a precursor to happiness? Meaning, must you have success before you can be happy, or should you be happy in order to be successful? That mindset, which suggests that you first need to be successful in order to be happy, is quite common, isn't it? People would say, oh, if I could only do this, if I can only get that, if I can only buy that, if I have the money, if I could only fall in love with the right person, then I'll be happy. How familiar is that as a thought? I was just thinking, am I going to end up divorced? Okay, now remember, I'm not a psychologist. All I'm doing here is, to just make you think, because I think about it a lot. Now, but research suggests that actually it is not success that leads to happiness. In other words, you can look at people who are very successful in their careers. They have the money, they're in fantastic positions, but they are very unhappy. Have you come across people like that? They're very successful, but they are extremely unhappy. And their unhappiness actually spills over to other people, because they can be very brutal in their dealings with other people. You can say, oh, how come this person is so unhappy? Research suggests that actually it is happiness that leads to success. So the happier you are, the higher is the likelihood that you become successful. And I like that thought, because if students can be happy in their lives and in what they're doing, then my sense is students will enjoy their learning and likely complete this unit. So that's my goal for doing this. I'm hoping that by getting you to think more about happiness, designing activities, creating the context and the situation that will make you happy, my sense is you'll be happy to learn, and you'll be happy, you'll end up completing this unit. I think that's a lofty goal. That's my reason. Will that be okay? Is that good? So I'd like you to think about that question as well. And 1 minute, and then we'll shift to the regular tutorial. What I'd like you to do later on is to reflect on that question. What is the value of happiness? Why would happiness matter? And what is the cost of unhappiness? What is the cost of being unhappy? Think about that. And if you had a choice, in other words, if you look at happiness not so much as a consequence of your situation, in other words, it is not your situation that determines whether you're happy or not. It is actually your approach to the situation. So people, for example, some people who are, who have cancer, some people have lost their jobs, some people who are sick, they can actually be happy. And some people have everything, they can be unhappy. So research suggests that actually your context, your situation, only accounts for 40% of whether or not you're going to be happy or not. A lot of it depends on you, on the activities that you do. So you can actually influence happiness, the happiness in your life. Isn't that liberating? So that, no matter what your circumstances can be, you can actually be happy. Okay, so I think I'm going to leave it there because it's 7:05. And I think I started with recording. Now, that's going to be strange, right? I shift straight away to the framework for judicial review. But so, I hope you start thinking about happiness, because I think about it a lot. And so having, spent that time, I again wish to, Monique is not happy, not happy. Okay. So thank you again for joining tonight's session. I like sessions where there are actually more people joining us at the tutorial. So tonight, we start talking about, it's kind of a strange shift, a strange segue. We're talking about happiness, and then all of a sudden we're confronted with the framework for judicial review. But that's the way it is. So we're going to be talking about the framework for judicial review, and after studying this topic, you should be able to discuss and explain the concept of judicial review, and when it is available to review administrative decisions, the framework and legal basis for judicial review in Australia, the requirements of justiciability in judicial review, the instances when an application for judicial review under the ADG Act can be made, and so on. Okay, so those are the objectives, and these are in the study guide, as well as, it is in the study guide, as well as in the relevant section in Moodle. Now, what we're going to do in order to dig deep into administrative law concepts is actually to look at cases, because when we have the final examination, it's going to be based on case problems that I'll be formulating. And so to familiarize yourself with the final examination, we're going to go work through problem-based questions. So doing so, working through factual problems where there are facts, enables us to kind of practice that task of and providing legal advice and giving correct problems to problem-based questions. And it allows us to go deeper into certain concepts. Okay. Before I proceed, would any of you have any questions or any comments? So if you will notice, I've actually muted everyone. So if you want to say something, you can either raise your hand or you can unmute yourself. So before I continue, I'll give you a chance to say a few things if you want to, ask questions, provide comments, and so on.
Excuse me, Manjo, it's Monique. Just wondering if you will provide the your suggested tutorial responses like you did in constitutional law.
I will be.
Thanks. And also just wondering if you have identified those key cases in the case list yet.
I should do that either by tomorrow or I'll do that over the weekend.
Okay, thank you.
Thank you.
Manjo, I just have a question about the...
Who's asking there?
Sorry, it's Lois.
Lois, yes.
I just have a question about the quizzes.
Yeah.
Is it possible to have them so that they are due on the Sunday like they were in constitutional law? Because I'm really bad at remembering to do it on a Thursday.
Probably. So if it's really going to be Sunday, I'll open the quiz on, let's say, Sunday instead of a Friday, and then it closes on the next Sunday.
Yeah, I think in constitutional law we had them open on the Monday and due the following Sunday.
Yeah, the problem I have with that idea is that what I would, because remember for quiz 1, it actually refers to the week 2 topic. And because they opened it on Friday and it closed at 5 p.m. today, I could then discuss the quiz answer in the course of the tutorial. Now, if I were to do it, if I were to open it on Sunday and close it on the Sunday afterwards, I can't discuss the quiz during the tutorial. So I think that's the problem there.
Yeah, that makes sense.
Yeah, so what I'll probably do is to just keep on reminding students to, you've got 1 week. I'll just keep on reminding you that you've got a quiz that you need to finish. But because it closed at 5 p.m. today, the quiz 1, we could actually discuss it during the tutorial, which I think makes sense, because otherwise, when we go to week 3, and then, it's difficult to just go back to that quiz because, maybe it's no longer current in the minds of the students. So we'll probably keep it as it is, if that's all right. Okay, now...
Yeah, that's fine. Thank you.
Thank you, Lois. We don't have Monica Thompson today, do we? I was trying to look for her name here. Because Monica Thompson came up with a fantastic framework about how to determine whether or not judicial review is available. She put it up as an answer for the discussion 5 question in Moodle. And we will try to spend time on that because she did very good preliminary work. So well done, Monica. I'm hoping you're going to see this recording anyway. Okay, so can we proceed? I'm not sure if we'll be able to cover all the questions, but we'll give it a go. So that's tutorial question 5. That's the first tutorial for tonight. Can I get a volunteer to read question 5 for us, just to read it? Can I get a volunteer, please?
I'll read it if you want.
Thank you, Amanda.
After years of working as a disability support worker, hang on, I've got to move everybody out of the way because I can't see the rest of the screen, sorry. After years of working as a disability support worker, Sharon Hills decided to set up her own business providing support to disabled persons. The Disability Support Workers Act Commonwealth requires that operators, owners or managers of businesses seeking to provide services to persons with disabilities must have a business licence from the Australian Department of Social Services. Such a business licence may be given only to persons who have had professional experience as a disability support worker for 5 years and who are of good moral character. The Act also provides that an application for a licence must be made not later than 30th of June of the same year. Sharon applied for a licence on the 18th of June. However, after staff of the ADSS did not accept her application because her documents showing her years of professional experience as a disability support worker were incomplete, she returned on the 27th of June, Friday, to submit further documents, but these were still considered incomplete, and so her application was not accepted. On the 30th of June, she returned with the complete set of documents on her professional experience, but was then asked to provide further evidence relating to her good moral character. She returned the next day, or the 1st of July, to submit the necessary documents, but the ADSS refused to accept her application because it had been submitted after the deadline. Sharon is frustrated and angry that her application was not accepted and has come to you for legal advice. Assume that recourse to the Administrative Appeals Tribunal is not available. Advise Sharon on whether judicial review is available and why.
Very good. Thank you. Okay. Would anyone care to give an advice on whether judicial review is available?
Manjo, it's Peter Anderson.
Yes, Peter.
I've actually got a question on this. But
Go ahead.
going back to the notes in the,
Okay.
you know, is it jurisdiction,
Yes.
justiciability, standing, grounds, remedy. Those were the five key points you look at to determine the answer.
Mm.
And I guess I'm struggling a little bit about some of those particular points or elements.
Yep. Did you have a question, or you kind of said you had a question there?
Well, the question is, how do we determine answers from those 5 points? Now, I don't quite understand jurisdiction.
Okay.
We talking it, you know, I work in an environment where jurisdiction means something different, I think. And I've been going through the notes and things like standing and grounds, I've got a pretty good understanding of that, but jurisdiction and I think justiciability is a little bit of a problem area for me, and how remedy fits in, I just don't quite get it at this point.
Fantastic. So do you mind if I kind of provide some background in response? I mean, I talk to the rest of the class. Is that all right? So which is the purpose of the tutorial, to elucidate. So let's begin. Let's talk about jurisdiction in general. There are actually many senses in which you look at jurisdiction. You can have jurisdiction over the subject matter. You can have jurisdiction over the person. You can have jurisdiction in terms of the geographic area. You can have jurisdiction over the object. So when you say, for example, you talk about jurisdiction over a person, that's when a court acquires jurisdiction over a person or is able to exercise its power because certain persons have come before the court. When we talk about jurisdiction of the court, we're actually talking of the power of the court to resolve a controversy before it. So it's jurisdiction subject, it's what is known as subject matter jurisdiction. Okay, now, what is the basis of subject matter jurisdiction? When you look at the High Court, for example, it has what is known as subject matter jurisdiction as a result of the Australian Commonwealth Constitution. So when you look at Section 75.3 and Section 75.5, for example, it says that the High Court has original jurisdiction in relation to the issuance of writs of prohibition, mandamus, and injunction concerning officers of the Commonwealth. So that is jurisdiction over the subject matter. as a result of the Constitution. There is also jurisdiction on the basis of what we know as common law jurisdiction. And this is historically, this has been a result of the attempts of the courts of record of the UK, which was then transplanted over to Australia, where the courts sought to regulate certain activities of the executive to ensure that there were no abuses. And you will probably come across cases such as Entick versus Carrington, where the court then said, that was probably 1765, that it is within the power of the courts to actually control and regulate activities of the executive. So there is common law jurisdiction. In other words, despite the absence of provisions in the Constitution or of a statute, written law passed by the Commonwealth Parliament, the courts, as a branch of government, have asserted their power to police the exercise by the executive of its power. So that's known as common law jurisdiction. We also have what is known as subject matter jurisdiction on the basis of statute. So that's statutory jurisdiction. And that is because the Commonwealth Parliament, for example, in relation to the federal courts, have the power under Article 7, Section 76 of the Constitution to define, to create Chapter 3 courts and to define the jurisdiction of those courts. So when you say define the jurisdiction, we're actually also referring to subject matter jurisdiction. In other words, what are the cases or what are the controversies that a federal court, for example, has the power to decide and to determine? Okay, so we talked about jurisdiction of the subject matter. It can be because of the Constitution. It can be because of the common law. So in other words, even in the absence of a constitution or in the absence of a statute, the courts have asserted their authority to police the ranks of the executive, and we have statutory jurisdiction. Now, the Federal Court of Australia, as well as the Federal Circuit Court of Australia, as well as the Family Court of Australia, these are examples of courts created by the Parliament. So these are courts created by statute. Unlike, for example, the High Court, which is a creation of the Constitution. So the Commonwealth Parliament cannot divest the High Court of its original jurisdiction under the Constitution, nor could the Commonwealth Parliament do away with the High Court of Australia. But because the Federal Circuit Court and the Federal Court of Appeals are creations of the Commonwealth Parliament, the Commonwealth Parliament can actually change the jurisdiction of those courts. So having said that, we've kind of, I think, discussed what jurisdiction is, right? Was that clear enough? Let's move over to the issue of justiciability. So justiciability, as we realized later on, really relates to the question of whether or not when there is a controversy, an actual controversy. Now, let's begin by talking about disputes that come before federal courts. So there is a requirement in the case of in re judiciary that, and as well as the Boilermaker's case, that federal courts can only exercise jurisdiction when there is a matter. And there is a matter, according to the case of Hardert Parker versus Moorhead, only when there is an actual controversy before a court involving persons or involving citizens against another citizen or the citizen against the state, which involves the rights, liberties, or interests or legitimate expectations. So there has to be an actual controversy. There would be a matter. But even assuming that there is a controversy, the question that might be relevant for the court is whether or not it is a question that is appropriate for the courts to determine or to decide. There will be cases, if you look at Pecco-Walson, the case of Pecco-Walson, where a case, even if there's an actual controversy, it is not appropriate for the court to make a decision on it because it requires the exercise of political judgment. It may require the exercise of national policy. And in that case, because of the concept of representative democracy, the idea is that there are certain political decisions, judgments, such as about national security, for example, which are best left to the elected members of the government, such as the Commonwealth Parliament, to decide. And in that case, the courts will not second guess what the elected officials will decide. There's another aspect to justiciability, and that is whether or not in deciding an actual controversy, will the courts be using legal standards as opposed to political standards. So for example, questions about whether or not there should be death penalty is a cruel and unusual punishment which should not be permitted. It can be argued that that requires political judgment. There is no legal standard as to what can be cruel and unusual punishment. And in that case, the courts will likely not intervene and say that, that is a non-justiciable question. Now, justiciability can also relate, actually, if you look at the cases, into the question of whether or not a person has standing before the court, because another requirement, as we see, is that a person must have a standing, meaning his rights, his legitimate expectations, or his interests must be affected by a decision. And that's why he comes before a court. And so a person who does not have a right, or whose rights are not directly affected or individually or uniquely affected as opposed to everybody else being affected, that person will not have standing. So there's a requirement of standing. So we've gone through jurisdiction, justiciability, standing. And then there is a requirement. So when it comes to judicial review, what we need to remember is that courts don't really have appellate jurisdiction in the sense that they can review decisions of the executive on the basis of findings of fact. Because in that case, it would be as if the courts are over and above the executive. So there is a recognition that the courts will only intervene to police the exercise of executive power when the executive exercises its power and that the exercise of that power is contrary to law. So it has to be in relation to a legal question. So factual questions generally do not fall within the ambit of judicial review. Are we clear about that? We'll see exceptions later on because there's such a thing as no evidence. But that comes, I think, in week 8. So in general, when you speak of a judicial review, the ground for review can only be on the basis of illegality or illegal error or unlawfulness of the decision. I'm having difficulty looking. Monique's posted something there. I can read it for now because I'm saying something here. I'll have a look at it shortly. So finally, the other thing is remedy. That if you're going to seek judicial review, you must be clear about the judicial remedy you're seeking. The advantage of the Administrative Decisions Judicial Review Act of 1977 is that it provides a lot of remedies compared to the remedies we see in according to the Constitution, Section 75(5), where the writs are limited to prohibition, mandamus, and injunction. That same provision is found in Section 39B of the Judiciary Act of 1903, which gives the federal court the power to issue writs of mandamus, prohibition, and injunction in relation to the officers of the Commonwealth. So that is a similar provision, but relating to the Federal Court of Australia. So you will notice, therefore, that in relation to the Judiciary Act of 1903, as well as the Section 75(5) of the Australian Commonwealth Constitution, the remedies are very specific: prohibition, mandamus, and injunction. We also what is known as common law or prerogative jurisdiction, prerogative writs, but I don't want to get into that. So the important thing is that if you're speaking of the Judiciary Act of 1903, you're limited. Your recourse is limited to those 3 writs. Okay. On the other hand, if you're able to seek an application for judicial review on the basis of the ADJR Act, there is a wider scope for the exercise of judicial power. So that's the beauty of it. But then the question becomes, does the Federal Court of Australia, for example, or the Federal Circuit Court have jurisdiction over that particular matter or problem before it? Because as we see later on, a key requirement, and this relates to Tutorial Question 5, a key requirement for a federal court to have jurisdiction under the ADJR Act is that, among others, the decision must be of an administrative character and it must be a decision made under an enactment as defined by the ADJR Act. So in other words, if the decision is not based on an enactment as defined under the ADJR Act, then the Federal Court of Australia or the Federal Circuit Court does not have jurisdiction over the case. Clear so far? Yeah, questions? So having said that, can somebody try to answer question 5? Monique, what do you think? I saw your answer here.
Oh, sorry. Yeah, I'll read it. I didn't answer it earlier, so I thought I'll try and put together an answer, and I would have forgotten by the time you asked me, which is why I wrote it. So I thought that Sharon would not have grounds for review, although the decision appears to be one which the ADGR Act would apply to, because it is administrative in character and made under enactment. She would not be able to satisfy any of the grounds for review under sections 5, 6 or 7 of the Act. And the decision appears to be based on clear guidelines set out by, I couldn't read that. I couldn't go up on the screen to read must be the pictures of everybody, sorry. Under the Disability Support Workers Act, because she's just failed to submit the documents in time and in accordance with the requirements. So it's quite clear that she hasn't met those requirements, and it's not a case of somebody acting outside what the provisions of the Act are that she's applying under.
Thank you, Manny. Now, it's kind of unfair to you guys to have to answer this question, because we haven't really talked about grounds for judicial review, because we covered that later on. So just for now, I'm just going to mute everyone again. For now, hang on, I'm going to mute all. Okay. So for now, let's just assume that there is a ground for judicial review. Okay, on the ground of a breach of natural justice, which suggests that that people have a right to be heard if a decision affects the rights, interests, or legitimate expectations. So, assuming that there is a ground for judicial review on the ground that there is a breach of natural justice, the question then is, would the ADGR Act apply? In other words, would a federal court or the Federal Circuit Court or the Federal Circuit Court have jurisdiction under the ADGR Act to take cognizance over this particular matter? So that would be the basic question there. Now, so let's go through this. There is a decision. The question is there an administrative decision? When do we know that a decision is administrative? How is that defined? Can somebody provide an answer? How do we know that it is? So how do we know that a decision is administrative as opposed to a legislative decision or a judicial decision?
It's a subjective decision as made by the administrators of the executive.
Okay. So who was that? How come I can't see who's giving an answer here?
Carl. That was Carl.
Who was it? Carl.
Yes.
Okay, thank you. So there have been controversies as to whether a decision is actually administrative, judicial, or executive. But a simple way of looking at it is that when a decision is made by somebody in the executive, so let's begin, because some of you may not have taken constitutional law. There are 3 branches of government in Australia, and generally in all governments for that matter. You have the executive, you have the legislature, which is the parliament, and you have the judiciary. 3 branches of government. The executive, you'd have the prime minister, the cabinet, and everybody else under the part of the executive. So it could be ministers, it could be certain departments, and so on. They all form part of what is known as the executive. So if a decision is made by anyone in the executive department, not in the legislature, not part of the judiciary, then it can be said that the decision is one which has an administrative character. Now, if you go through the cases, which I don't have the time to do now, that can become tricky because there are certain cases where it's not quite clear-cut whether or not a decision, if you look at the case of Irenaeus as well as the case of Roche, you'll have cases where it's not clear-cut whether or not a decision is actually an administrative decision. But we're not going to get into that just because we don't have the time, and I'm not going to be asking questions on that anyway. So just as a shortcut way of looking at it, if a decision is made by somebody who is part of the executive, then that is an administrative decision. Now, the question, however, whether or not, assuming that the decision is one of an administrative character, and the question of whether or not that administrative decision is then subject to the ADGR Act is totally different, because the requirement under the ADGR Act is that the decision, the administrative decision, must be based on an enactment. Okay, and we're going to see that that's problematic in two senses shortly. But for now, and we're gonna revisit that point. Okay, but for now, the answer is I would advise Sharon that she has grounds for judicial review under the ADGR Act, because the decision is one which there is a decision there. She is aggrieved by the decision because she has not been given a license. And the decision is of an administrative character because it was made by somebody from the Australian Department of Social Services, which is part of the executive. The decision was made based on an enactment. It was made under enactment, which is the Disability Support Workers Act. And it is not an excluded decision under the ADGR Act. And so in that case, she can apply for judicial review under the ADGR Act. So let's just leave that for now. Questions so far?
So sorry, Manjo. So were you just asking us to say whether or not she would have a right to apply? Is that what you're saying? You didn't want us to sort of, sorry, I'm just a bit confused. So she would have a right to apply because the decision was administrative in character and made under enactment?
Yes. She's agreed with the decision.
Okay, but we weren't to assess whether or not it was likely to meet any of the other requirements. Is that right?
Other requirements in the sense that it's going to or like grounds for judicial review?
Yeah, that's right.
Yeah, we assume that there is a ground, there is a natural justice, but for this purpose, I don't want to go into the grounds because we're not discussing it yet. We will discuss it. But there is a potential ground she could raise that there is a breach of natural justice in the sense that she did not have the right to be heard. Her right to natural justice or the right to be heard was actually breached because she was not given an opportunity to present her documents. So but we're not going to delve into that because that's
sure.
Okay. So let's proceed. Okay. Can somebody read tutorial question 6 for us?
Yeah, I will.
Thank you.
The Australian newspaper reported that a federal government commissioned report has detailed widespread and systematic abuses of boat refugees in Australia's refugee facility in Manus Island. The Australian Refugee Consortium, an Australian non-government organisation, asked the Minister for Immigration and Border Protection, who commissioned the report, to publish it, but he refused. The consortium has approached you for legal advice on whether it has valid grounds to apply for judicial review on the Minister's decision not to publish the report. Give your advice.
Thank you. You could try to put your answer in the chat box, or somebody could pick up the mic.
Manjo, my name's James. I wasn't with you last week, but I thought in this one, the Australian newspaper, the Australian Refugee Consortium weren't aggrieved by the decision, and therefore they'd have no standing to appeal it.
Very good. That's the correct answer, James. Very good. So there is one problem that's here. You're probably going to advise, as correctly pointed out by James, that the Australian Refugee Consortium does not have legal standing because it has no legal right or interest or legitimate expectation which has been breached or violated or interfered with by the decision of the minister not to publish the report. So there's a problem of standing. But apart from that, let's assume that there is somebody who was standing, and that is, one of those refugees, once it published. So let's assume they're standing. The question is, would you advise a refugee, one of those refugees in Manus Island, would you advise that you apply for judicial review of the minister's decision not to publish the report?
I'm just going to repeat what I wrote there. No, because it's a prerogative power, so it's not made under an enactment. and it's not under a statutory review, power of review.
Uh-huh.
So it wouldn't be that it's excluded under the ADJR Act.
Very good. So let me just write that down because that is the point of prerogative power. Okay. So who said that?
Me, Mira.
Who was that? I identify the speaking. Sorry.
Mira.
Mira. Okay. Thank you. Okay. I'm gonna mute everyone again. I'm getting some background noise. Okay. We're gonna get back to that. Okay. So that's a good point that Mira has pointed out. She says that judicial review is not available because the decision was not based on an enactment, but actually the exercise of prerogative power. Very good. We're going to get back to that, okay? Because that is not the answer to the question. But we're going to get back to that in a short while. But thank you, Mira. So that's an important point. But would the court actually have jurisdiction? Would the court likely exercise its jurisdiction to do a judicial review of the minister's decision of judicial review? Because remember, we have at least three legal basis for judicial review. We have the Constitution, which vests in the High Court the power to issue writs of mandamus, prohibition, and injunction against officers of the Commonwealth. So in that case, we have Section 75 of the Constitution, Section 75(5) of the Constitution. Did somebody raise their hand? Sorry.
Yes,
Yes. Peter, go ahead, please.
Yes, I believe that a refugee could apply for a judicial review there because they have the standing. They're involved in the case. They're part of the case, so that they've got standing. It is I can't pronounce that word ever.
Justiciability.
Yeah.
I think that's something else. I'm not sure. Okay.
Yeah, and they have been aggrieved, and it does affect them directly. So yes, I believe that the refugees could apply for a judicial review in that particular case.
Okay. Maybe so the other question is, how likely is it that the court will actually exercise its power of judicial review, assuming that there is legal standing on the part of a refugee? Remember, we've kind of changed the facts a bit. We're now saying that the potential applicant is a refugee of Manus Island. So assuming that the problem about legal standing can be overcome, the other question is, how likely is it that a federal court will exercise its power of judicial review over the minister's decision not to publish the report? That's my other question there.
Well, it'd have to be a breach of law, so either statute or common law through natural justice. The report, if the government commissioned the report under some form of statute by, I don't know, whether they introduce some form of act or regulation for it, or if somebody believes that, and they have standing, that it's part of their right for it to be heard because of the situation that they're in. Then they could say that you could argue that yes, they do have standing if there is a breach of either statute or common law.
Very good. Now, actually, the focus of this question is really about justiciability, which Peter alluded to, and which Peter was actually asking about later on. Do I have a tendency to speak too fast? Or am I okay in terms of the speed by which I speak? I kind of get excited sometimes. So I try to slow down. So the question, the point of this question, apart from the question of standing, which was correctly identified by James earlier, really raises the question of justiciability. Is this a question? Does this involve a legal question? Or does this involve a political question? Chances are that a federal court will not entertain or is unlikely to exercise its power of judicial review because this requires the exercise of political judgment. Because obviously, if it gets published, it can have repercussions for the Australian government. Now, whether or not, so it requires a policy as well, because it can lead to lawsuits, whatever. It can mean that there'll be issues about intelligence, national security issues, and so on. And so in that case, if we follow the case of Minister of Arts, Heritage and Environment versus Pecco Wilson Limited, where a decision of the executive rests more on a political judgment or political considerations or political policies, then in that case, that becomes a non-justiciable question. Courts are unlikely to exercise their power of judicial review. And this is what I would suggest, that if I were the lawyer, even assuming that my client has legal standing, because under the changed facts, the client there would have been a refugee of Managed Island, I would advise against applying for judicial review because it involves a non-justiciable question, because whether or not to release the report involves a political decision, political considerations, and so on. Clear? Now, no questions so far? Let's talk about prerogative.
So separation of, so Manuel, what you're saying is then the separation of,
sorry, Manjo.
separation of powers.
Yes, so under the separation of powers, courts make decisions on the basis of what is legal and not legal. Political questions or political decisions are made by the elected officers of the government. So that's either the executive or the parliament.
So sorry, Manjo, just going back to the question as it's written, was the correct answer the advice that they just don't have standing in this situation, but then you change the facts to if it was an actual refugee who was seeking advice, and then we got to the justiciability issue. Is that right? Just to clarify.
Thank you, Monique, for asking that question. If we stick to the facts, as we see on the screen, there would have been two reasons why a lawyer should advise against an application for judicial review. One is that the Australian Refugee Consortium does not have legal standing. But secondly, because the decision not to publish the report involves a political question. In other words, it is non-justiciable. So as a lawyer, based on the facts as we see it right now, without changing anything, I would advise against applying for judicial review, both because the ARC does not have legal standing, but secondly, the executive decision to publish or not to publish the report involves a political question or a political decision. Therefore, it is non-justiciable. And courts will refrain from entertaining questions that involve political questions. Okay, we're clear with that? Let's move on to the point about prerogative power. Where do you suppose the question about prerogative power and not made under an enactment come in? Why is that relevant? Why is that important? So let's just assume, kind of changing the facts a bit, okay? Or maybe in general, let's assume that what is involved is a legal question. Let's assume, okay? In general. Let's also assume that a factual scenario involves a situation where there is a potential applicant with legal standing. But the question arises where, on the basis of the exercise of executive power, and there's an administrative decision, the question arises whether or not the applicant should apply for judicial review. Where does prerogative power come in, and the question about not made under an enactment? Can somebody have a sense? So let's assume that an executive made an administrative decision not on the basis of an enactment. It could be based on executive power in general, under the Constitution, or it could be the exercise of prerogative power.
There's not a duty. What they have done and what they're doing, they're not held by a duty of as prescribed by the legislation. So the point there really is, if therefore the executive exercises its power not under an enactment, but on the basis, say, of prerogative power or executive power in general, does it mean that there is no scope for judicial review? In other words, can there be judicial review only when an administrative decision is made under an enactment, or can there be judicial review of a decision even when the administrative decision is not made under an enactment, but the exercise of executive power or the exercise of prerogative power?
And then I'll go to the question here by Jess in a short while. Was my question clear? Was my question clear? Okay. So let's repeat the question. What was the question? So the question was, let's assume that the executive made an administrative decision, but the administrative decision was not made under an enactment. It was made on the basis of the exercise of executive power under the Constitution, or on the basis of what is known as prerogative power, which I'll define shortly if need be. The question is, if an administrative decision is based on executive power in general, not made under an enactment, is there scope for judicial review? That is the question.
Under common law, there would be.
Very good. So the point about who was that? Was it James? Who was it? Who gave that answer?
That was Carl.
Carl. Thank you. That's a good answer. So the point about an administrative decision being made under enactment is important only for the purpose of determining whether or not the Federal Court of Australia or the Federal Circuit Court can exercise jurisdiction under the ADJR Act of 1977. Okay? But assuming, now, the beauty of making an application for judicial review under the Administrative Decisions Judicial Review Act of 1977 is that the powers of the court are actually broader than the writs of mandamus, prohibition, and injunction. Are we clear? They're broader. They're also broader compared to what are known as the traditional common law remedies, such as declaration. Okay, so that's the beauty of the ADJR Act. And the ADJR Act actually codifies and simplifies the process of judicial review. In other words, as a first step in relation to the question of Jess, the best thing you can do in relation to asking the question of whether or not you can apply for judicial review is to always ask first that question. Is this administrative decision best reviewed under the ADJR Act? That's always the best question. That's always the first test you do, because it's easier. That is, in fact, the purpose of the ADJR Act, to simplify the judicial review process, because if you rely on the Judiciary Act of 1903, there are limits to the powers that can be exercised by the court, meaning the reliefs that can be given. If you rely on the common law writs, there are also constraints there. So to make it, so in other words, prior to the ADJR Act, there were a lot of administrative decisions that could not be reviewed by the courts, simply because the relief were not available. And hence, the reason why the ADJR Act came about. So the first question you should always determine is, can an application for judicial review be made under the ADJR Act? The problem, however, is that for an administrative decision to be reviewable under the ADJR Act, the administrative decision must have been based under an enactment, made under an enactment. Clear? Are we clear about that? Now, assuming that the administrative decision was not based or was not made under an enactment because it involved the exercise of the executive power under the Constitution, or exercise based on prerogative powers. So prerogative powers are the inherent powers of the executive, even in the absence of the Constitution, empowerment of the Constitution or authorization of the Constitution. It is recognized that the executive can do certain things, even in the absence of the Constitution, or even in the absence of enabling law coming from the Common of Parliament. So these are residual powers of the executive, known as prerogative powers. So even if the executive were to make administrative decisions on the basis of the executive power or prerogative power and not under a statute, which is a creation of the Commonwealth Parliament, judicial review can be available both on the basis of Section 75(5) in relation to the original jurisdiction of the High Court. It can also be based on Section 39B of the Judiciary Act of 1903, or in general, what we know as common law jurisdiction of superior courts of record. Clear so far? So in other words, even if it is, so that's important. So even if a decision, an administrative decision was made, and it was not made under an enactment, potentially, there is still scope for judicial review. Clear? However, the problem with seeking recourse under Section 75.5 or Section 39B of the Judicial Act of 1903 is that the remedies are very limited. The remedies are limited to the writs of prohibition, mandamus, and injunction. It doesn't permit for example, for declaration. So there are limits to the relief. In other words, if therefore you cannot seek those specific legal remedies under Section 39B of the Judicial Act of 1903 or Section 75, the application for judicial review will still fail. Are we clear? Clear so far? Now, let me just introduce another element here. The thing is, when you look at Section 75.5 of the Australian Commonwealth Constitution, and when you look at Section 39B of the Judicial Act of 1903, they relate to the issuance of writs of mandamus, prohibition, and injunction against officers of the Commonwealth. Now, let's assume that an administrative decision was made not by what is clearly part of the executive, but let's say by a private agency hired by the government. Now, remember, in Manus Island, for example, the organization that's running the show is not the Department of Immigration and Border Protection, right? It has contracted that function to a private agency. Is that correct? Correct? It is a private agency. And the private agency, therefore, makes decisions. So in law, the private agency is not an officer of the Commonwealth. It is not. Clear so far? Now let's assume, so we're kind of extending this a bit. So let's assume that a decision has been made by a private agency contracted by the government. It could be about, I don't know, collection of tolls. It could be about collection of the garbage, whatever, and so on. But contracted out by the government to undertake certain public functions. So we know today that because of privatization, commercialization, contracting out, and so on, the government has devolved certain public functions to the private sector. We know that, right? And the question is, if those private agencies undertake public functions and they make decisions that affect the individual, is there recourse to judicial review? That's the bigger question. Because remember, as we said, if it is based on the ADGR Act, it has to be a decision made by the executive. So you can't have it under the ADGR Act. If it is based on Section 39B of the Judicial Act of 1903 or Section 75.5 of the Constitution, it has to be a decision made by an officer of the Commonwealth. Now, what happens in those instances when the decision is made by an agency undertaking public functions? So, the decision on that point is not well settled. In many cases, the courts have said that they won't have jurisdiction because it is not an officer of the Commonwealth. So Section 75.5 is inapplicable. Section 39B of the Judicial Act of 1903 is also inapplicable. But actually, if you examine the case of Forbes versus New South Wales Trotting Club. So Forbes versus New South Wales Trotting Club. A decision was made by a private company, which was the New South Wales Trotting Club, which is about horses, I think, where they made a decision to prevent Forbes from entering the grounds. But in this particular case, the court permitted an application for judicial review because although it was a private agency, it actually, in a sense, undertook certain public functions. It became a public function when it began to regulate certain activities that were open to the public. So you can have very limited cases of judicial review under common law judicial review, not under Section 39B of the Judiciary Act. Are we clear? I raised that because we talked about common law jurisdiction. Okay, questions so far? We're good. We're good. Oh, yeah. Yes. Was there a question?
Yes, Jesse here.
Jesse, yes.
Can I just be clear on one thing?
Go ahead.
In front of me, your two study guides for this week. The first one is judicial review under the common law. The second one is judicial review under the ADJR Act.
Yes.
Now, if the problem question, if the decision is not made under an enactment, I disregard this second study guide and just reply solely on the judicial review of common law and the principles found there within.
Were you asking me? Oh, was that a question? So that if a decision was not made under enactment, you were suggesting we don't look at the ADGR Act. Was that the point you were trying to make?
Yes, yes.
Okay, you're right. So if I was looking at the comment here from James. So if a decision was not made under an enactment, then definitely you cannot seek recourse under the ADGR Act. But that is not the end of the question. You then ask, can judicial review be made under Section 75(5) of the Constitution? In the sense that, can the High Court exercise its original jurisdiction to issue writs of mandamus, prohibition, and injunction against officers of the Commonwealth? Or can you rely on Section 39B of the Judiciary Act of 1903, where the Federal Court of Australia has the power to issue writs of mandamus, prohibition, and injunction against officers of the Commonwealth? That will be the next step. So if not the ADGR Act, can you rely on Section 75(5) of the Constitution or Section 39B of the Judiciary Act? If that's not possible, can there be scope for common law judicial review? Now, the idea about common law judicial review, it's not often used, so it's really very unlikely to be using it. Where was that from? PETA, the Job Secretary of Harness Racing Club. Okay, so but you examine the possibility of common law judicial review. The problem really, as I said, when you seek recourse under Section 75(5) or Section 39B of the Judiciary Act or common law judicial review, you need to be able to identify the specific legal remedy that you want. Because if the legal remedy is not there, the action is simply going to fail. We will see this when we look at the case of Green versus Daniels, a decision made by the High Court, where the High Court judge said that even if he were inclined to actually agree that there was a ground for judicial review and that the action should prosper because there was a breach of the rights of an applicant, still the court could not grant the remedy that was sought. So that's the problem. Even if the court could exercise judicial review, there are limits to the powers that it can exercise. So in the case of Green versus Daniels, the court said that it was hamstrung. Even if it agreed that there was a ground for judicial review, it could not grant the remedy that was sought. The remedy there that was sought was to compel the executive decision maker to grant the benefits under the law. We will see later on that courts cannot make decisions on behalf of the executive. It can quash a decision, it can unmake a decision, it can set aside a decision, but it cannot order the executive to decide in a particular way. Okay, questions, comments? Now, what I'd like to point out, because we're almost at 8 o'clock, is that I will give answers to the questions to these problems. I'll in fact post them maybe in a few minutes after we have this tutorial. So I have the ready-made answers. So you'll have a sense of what the answers should be. Let's just look at tutorial question 7 quickly, although I don't mind extending a bit, although some of you may go hungry, so you may want to go. The point here is that the question is, okay, can somebody, because this is relevant to the quiz for quiz 2 as well. If you don't mind, those who need to go can go. Can I just get somebody to read tutorial question 7 for us? And then, if I had the time, I would have wanted to discuss Australian Broadcasting Tribunal versus Bond as well. But I don't know if we have the time, if you wanted to stay on, because that is a very important case. I'll try to discuss that next time. Okay, so some are happy to stay on.
Thank you.
Who was that? So I'm happy. So some are happy to go overtime. I'm happy to go overtime as well. But before we do that, so I could discuss Australian Broadcasting Tribunal versus Bond, because that is a very important decision. So we'll have to spend time on that. And I don't want to discuss it next week because that's about merits review. So if it's all right, for those who need to go, you can go. But I'd like to, if some are willing to stay on, I will extend. But let's just discuss tutorial. Yeah, so some can go. Thanks for coming. Now, let's just discuss tutorial question 7 because this is related to the first quiz. Can somebody read question 7 for us? And then we go to Australian Broadcasting Tribunal versus Bond.
I'll read it if you like. The Stellar Innovations Party Limited won a multi-million-dollar government contract in 2010 to build and maintain certain infrastructure projects as part of the Fast Track Infrastructure Stimulus Act 2010 Commonwealth. However, when Stellar Innovations Party Limited sought to bill the federal government for a portion of the project that had been completed, the Minister for Infrastructure and Regional Development refused payment. The Minister asserted that the contractor failed to comply with a key condition of the contract. After the Minister refused to reconsider his decision to refuse payment of the contract, Stellar Innovations Party Limited approached you for legal advice. The contractor wants to know if it can ask for a judicial review of the Minister's decision under the Administrative Decisions Judicial Review Act 1977. Commonwealth, give your advice.
Thank you, James. So let's just cut to the chase because we're kind of running out of time. The point here for this tutorial question, the legal issue for this tutorial question, just like the tutorial quiz, was whether or not this decision was made under an enactment. That's the legal issue there. Because if it is made under an enactment, assuming it is an administrative decision and there is a question with legal standing, then judicial review under the ADGR Act would be available. But if the decision was not made under an enactment, such as it wasn't made actually under the Fast Track Infrastructure Stimulus Act of 2010 Commonwealth, then the ADGR Act would not be available as a source of judicial review. So are we clear about the legal issue? Was this administrative decision made under an enactment? The answer is no. This decision was actually not made under the enactment, but on the basis of a general law of contract. It had nothing to do with the Fast Track Infrastructure Stimulus Act, even if the contract that was entered into was a result of this specific legislation. But the decision itself to refuse payment was not made on the basis of the Fast Track Infrastructure Stimulus Act of 2010 Commonwealth, but it was based on the general law of contract that the supplier failed to comply with the key condition of the contract. Okay, so the decision was not made under enactment, and as a result, because the decision was not made under an enactment, then the decision of the minister cannot be the subject of judicial review under the Administrative Decisions Judicial Review Act of 1977. That is also the answer for the quiz. The cases for this would be Griffith University versus Tan, as well as Australian National University versus Burns. So in other words, many decisions can be made by the executive, but they are not always made under enactment. In some cases, there may not even be any contract. And that is the case of Griffith University versus Tan. But because the decision was not made under an enactment, then you cannot have recourse under the Administrative Decisions Judicial Review Act of 1977. Clear? So the answer is, my advice would be that I would advise Stellar Innovations Proprietary Limited that judicial review under the Administrative Decision Judicial Review Act of 1977 is likely to fail. So I would advise against it because the administrative decision was actually not made under an enactment, but it was made under general laws, such as the General Law of Contract. And a key requirement for judicial review to be available under the ADGR Act is that the decision must have been made under an enactment. That is not the case here. Clear? So let's just move on. I'm gonna skip question 9 about Makepeace. Yeah, which is kind of actually related to the ABT bond. Okay, let me just go straight to the point. Because we're running out of time. This is a very long case. But in this particular case, this case actually involved a decision of the Australian Broadcasting Tribunal, which was created under an enactment. And the question for it was whether or not certain broadcasting companies that were actually owned by Mr. Bond, so whether those broadcasting companies were fit and proper persons to hold a proper license. That was the question. But for them to answer that question, whether or not these broadcasting companies were fit and proper persons to hold a proper license, there was a requirement to also determine who owned these broadcasting companies. Are we clear? So the question for the Australian Broadcasting Tribunal was whether or not these we'll just hold them companies, whether these companies were fit and proper persons to hold a proper license. But that question could only be answered by asking who owned these companies. So were the persons who own these companies also fit and proper persons? Now, there was a problem because these companies were actually owned by Mr. Bond, and at that time there were serious questions about whether or not Alan Bond, you probably are familiar with him, was a fit and proper person, because there were a lot of cases against him, controversies swirling around him. Now, the point was, the Australian Broadcasting Tribunal made a finding that Alan Bond was not a fit and proper person to be holding a proper license. Clear? Now, there was no finding yet that the broadcasting companies owned by Mr. Bond were fit and proper persons. There was a preliminary finding that the companies, that Mr. Bond himself was not a fit and proper person. The question was, could Alan Bond, at that point, seek a review of the decision? So this was a decision made under an enactment. Alan Bond obviously, was an aggrieved person. The question then was, that finding of the Australian Broadcasting Tribunal, finding that Mr. Bond was not a fit and proper person, which was a crucial determination to that next question of whether or not the companies he owned were fit and proper persons as well. But Mr. Bond, on the basis of the preliminary finding, filed an application for judicial review of that finding that he, Alan Bond, was not a fit and proper person. The question is, see you, Oluwayumi. The question was that decision made by the ABT appropriate for judicial review under the Administrative Decisions Judicial Review Act? So there was clearly a decision. There was an administrative decision. The decision was made under an enactment. So there was a decision. It was an administrative decision. It was made under an enactment. There is potential relief, and there is an aggrieved person. You tick off all the key elements. So the question is, would judicial review under the ADJ Act be appropriate on the basis of the facts? Yes, Peter?
No, I don't believe it would, because Alan Bond as a person was not directly involved in it. It was his companies that were involved, not him.
Okay. Now, but let's assume, Peter, that for our purposes, there was a finding that Mr. Bond actually had legal standing because it affected his interests. He was the owner of these, but so let's assume for the moment that the legal standing is not a problem. The question remains whether or not this would have been appropriate for judicial review under the ADJ Act. So let's assume for the moment legal standing is there. The question is would that be appropriate for judicial review when there was a finding that Mr. Bond was not a fit and proper person? From here, as you said, it was not a final decision. So the crucial point about this case is that not all administrative decisions made under an enactment are actually susceptible to judicial review under the ADGR Act. That is the crucial point. The point being that for a decision, for an administrative decision made under an enactment to be susceptible to judicial review under the ADGR Act, that decision must be final, substantive, and operative. Here, even if there was a finding that Mr. Bond was not a fit and proper person, it was not yet determinative really about whether or not the broadcasting companies would be given a license, because the ABT had not yet made a decision on that question. It was a preliminary step. The finding in relation to Mr. Bond was a preliminary step. So there was no final, substantive or operative decision. And for that reason, and this is very important, for that reason, the High Court said that judicial review, so he jumped the gun. Yeah, in a sense, Monique, yeah, he kind of jumped the gun. He should have waited for the decision to have been final, substantive, and operative. The other point here is that, you know, what you will observe later on is that when before an administrative decision is made, there are actually preliminary steps, right? It could be like, there could be hearings, there could be requirements, requests, or orders for parties to submit certain documents. There could be various other processes prior to the decision being made. Imagine if every single step of the way, whether or not decisions or conduct made by the decision maker, if that were subject to judicial review, what would happen to the courts? It would fragment the judicial process. And courts don't like that. And that is why this is a crucial point, that there can only be judicial review when there is a decision that is final, operative, and substantive. So preliminary steps, assuming that somebody, for example, was denied was denied the right to natural justice as a preliminary step, that may not necessarily mean that there will be a judicial review, because if that is a preliminary step, because that preliminary step can be rectified in the process. Okay? So I guess I'll end it there. Yeah, you're right, Monique. So if we allow, you know, every single preliminary step to be the subject to judicial review, courts would be swamped, and courts don't like that. Okay, so it's 8:12. Any questions before we end tonight's session? We're good. It's unfortunate I don't have the time to respond to Monique Thompson's proposed framework. I'll address this maybe over the weekend. I don't want to discuss this right now. It's 8:12. I want to rush off to the gym. Well, there's still time. It's 8:12 here in Queensland, but I'd like to rush off to the gym. So, any questions before we go? We're good? Okay.
Manjo?
Yes.
Manjo, the quiz question.
Yeah.
When will we know the answer to that?
The answer should be there straight away. It's actually number 3. He cannot apply for judicial review under the ADGR Act since the decision was not based on an enactment. So it's actually number 3. That's the answer to quiz 1. And I'll post the answers either tonight or tomorrow morning because I need to rush off to the gym before it becomes too late for me. Okay. So good night, everyone, and I'll see you next week. Bye.